Okay, we're going to call the meeting to order. I'm going to try to establish a quorum. Looks like we have 3 board members here, plus we have Dr. Zaff on the phone. Mike, can you hear us? Dr. Zaff?
I'm here.
Mike, can you hear me currently?
He's on a delay.
Mike, are you?
He'll be on a delay. He sounds like he's listening to you on the webcast. So that's like 30 seconds behind us. He needs to listen to us over the phone if he can. Can you hear us in the room?
Hear you.
If he could turn off the webcast, that would help.
Mike, you need to turn off the webcast and just talk on the phone.
Are you there? Hello?
Yes, can you hear me now, Mike?
Do we know?
Yeah, I'm going to watch this.
You can't watch it, Mike. You have to be on the phone.
Volume up on the webcast.
Can you not hear?
He can hear when the webcast.
No, I know, but
Okay,
you can't hear us over the mic.
Can you hear me now?
Yeah, we could hear you, Mike. Can you hear us?
Okay.
Okay, so Mike, it seems like you just got to talk on the phone and not pay attention to the webcast.
I'm on the phone.
Okay, and you're clear. You could hear me well.
It's not clear, but I can hear you. I can hear better on the computer, but I realize that's a delay.
Yes, and that won't work. So we'll just have to talk a little louder. Can you hear us better now?
No, I'm listening on the phone. I wasn't going to use the monitor. I hear is there a delay on the monitor?
Yeah, I don't think you should watch the monitor. I think you should just talk on the phone.
Got it.
Okay? Okay, once again, we're going to call this meeting to order. The Board of Podiatric Medicine meeting on September 9th. We currently have 4 out of the 6 board members. We have Dr. Michael Zaff via teleconference. You want to acknowledge yourself, Michael?
Again?
Yes, you're here. You're there, right?
I'm here.
Okay. And we got Dr. Neil Mansdorf.
Present.
Miss Christina Dixon.
Present.
And myself, John Shaw, is present. So we have 4 out of the 6 board members, and we have a quorum. Next, we'll go on to the President's welcome. I'd like to welcome everyone here to our meeting. One of our current board member, Melanie Masaniai, has resigned as of 2 weeks ago, and the governor's office has been informed, and hopefully they'll find a replacement. We'd like to thank her for her services over the last few years, and her presence definitely will be missed. Next item, I was able to attend the DCA's meeting with the board presidents and the executive officers, and I'd just like to go over a couple of brief items. Number 1, they wanted to remind all of us about our obligations regarding our training, such as the board member orientation, ethics training, sexual harassment, defensive driver, and Form 700. So if any board members has any questions regarding the specifics of how often they need to be taken, please let me know and I'll go over that with you later. Next item was an update on SB 1194. That is the North Carolina case. This was Senator Hill's bill where DCA supported to ensure active state supervision while maintaining autonomy of the state licensing board. DCA would have reviewed the board's decisions to determine antitrust issues. However, this has been pulled as of now and will be revisited soon. Apparently there was opposition among some associations and labor unions who had concerns. So this is going to be put off till a later date. Next item, I just want to say that the last 6 months has been pretty tough for the board and the staff with SB 1039 and transitioning of our new interim EO. I'd really like to thank everyone for their extra work, and especially staff for their extra time and devotion to the board. And the board really appreciates that. And right now we have Dr. Judy Manzi. Welcome. So we have 5 of our 6 board members present. Note about public comments. Any public comment is welcome on any agenda item. For those items that are not on the agenda, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda for future meetings. Okay, next item is item number 4, approval of the minutes. Has all the board members looked at the minutes of our teleconference board meeting on June 20th of this year?
I'd like to make a motion to approve the minutes.
We have a motion and a second to approve the minutes. Is there any discussion? Public comments? All right, those in favor? Dr. Mansdorf, you want it?
Mansdorf, aye.
Christina Dixon, aye.
Shaw, aye.
Judy Manzi, aye.
Dr.
Michael
Zapp?
Zeff, aye.
Thank you. That motion has been passed. Next, item number 5 is going to be our interim executive officer's report. Kathleen?
Good morning.
Good morning. This is Kathleen Cooper, the Interim Executive Officer of the Board of Podiatric Medicine. Starting with my report, I would like to invite, are the people from Budgets here? Okay. Marina?
Yes.
This is Marina O'Connor. She is a budget manager at DCA Budgets, and she's going to talk to us today about our year end as well as our current fund condition.
Good morning, and thank you very much for letting me present to you guys today. Your budget analyst, Marissa Ochoa, is sick today, so she couldn't make it, so I'll be presenting the budget information. And I think, were you guys going to put it up on the side?
Yeah, it's right there.
And then,
Yeah.
yeah.
This is the revised.
Yeah, well, what's up on the slide here, we'll start with, okay, so there's in your packet, there should be a budget report, an expenditure budget report, and a fund condition. I had some last minute changes to the fund condition. I needed to make some corrections to the revenue in fiscal year 16-17. So I think we have handouts for you guys with the corrected fund condition. And I think that's the one that's displaying up here too, is the corrected fund condition. But if you don't mind, before going over the fund condition, I wanted to go over the expenditure budget report first. So that's the other document in your packet. So I'm just going to point out a couple of things. So first of all, for 15-16, the column that says projections to year end, those are actually your fiscal month 13 actuals. So that's what you spent in fiscal year 15-16. And that's why it matches your current year expenditures column. So if you scroll down to the very bottom, your net appropriation, where it shows your unencumbered balance, which is the last column, it shows you reverted about $433,000 in fiscal year 15-16. So your full expenditure was about $1,445,000, including that includes your scheduled reimbursements for fingerprints as well. So that's basically your 15-16 expenditure report, what it looked like in 15-16. I apologize, I caught one small error on here on my way over. Under enforcement, there's a line item called DOI investigation. That's actually your evidence witness fees. It's not the DOI investigation expenditures, it's your evidence witness fees expenditures. So I apologize for there's that correction I just caught. But before moving on to the fund condition, do you have any questions on your expenditure report?
If we have specific questions around differences in budget versus.
Can you turn on your mic? I'm sorry.
It's on.
Is it?
Yeah. Can you hear me?
Just pull it a little closer
Yeah.
if you can.
If we have specific questions regarding the budgeted amount versus the actuals.
Mhm.
Do we ask that of you?
Yeah,
or-
I mean, you can, if I can answer it, I'll try.
So for example, with the Attorney General fees, I see
Mhm.
that we budgeted a pretty large amount,
Mhm.
and we've only spent half of that.
Mm-hmm.
Do we have any understanding as to why the fee, I mean, it looks like we're pretty consistent with what, not too far from what we did in 14-15, but did we set that budgeted amount, or how does the
So-
budgeted amounts get set?
So, the budgeted amount for a specific line item, is gonna be set through a number of ways. It could be going back many fiscal years, and it could potentially have not have been adjusted in a long time. I'd have to look back historically. But I think you did have, I'm trying to remember, I think you did have an AG augmentation in 15-16, or was that last? No, it wasn't this year, maybe in the past. So what can happen in prior years if you had, let's say you were budgeted, an amount for your AG, but you needed to expend more, you had more cases over there, you could have a current year budget augmentation, so that's one way it might increase. Other ways is through the BCP process, which technically it would be more of a technical adjustment. But that's ways to increase or decrease your AG budgeted amount. But typically it's going to be higher than what you expend because you never know when you're going to have, 1-2 cases that go out 3-4 years, or or take a long time for the AG to work, or a lot of hours. So it's a somewhat unpredictable expenditure. I mean, yes, you can see consistency maybe across the last few fiscal years, but you just never know when you're going to be hit with a huge AG expense. So that could be why it's higher than what you've been spending the last few years. But as far as where it originally came from, it could have been adjusted multiple times over the years, and that would require looking back at your prior budget history, probably going back quite some time.
Yeah, if I may respond, in this particular instance, it's always budgeted much higher because your AG costs can soar just from a single or multiple cases. And if you're budgeted too short, later on when you're reevaluated by the department for it, but they may actually want to take money away. So this particular line item has to be high.
I guess my concern is just that there are other line items that are under budget, so it may be, we're not having a cushion, but when you see other line items that are under budgeted, maybe there just needs to be some adjustments. The next question I have is, under the statutory exempt EO, I'm noticing that there's, an overage on expenditures. Can you tell us what that is?
Yeah, I believe that was partly due to a lump sum to your prior EO. Usually if there's any, I believe it's vacation hours left, those, when you leave the state, those are paid out, those remaining vacation hours. So that's probably why it's higher than what you were budgeted for.
And then the last question is at the very bottom, there's a series of scheduled reimbursements.
Mm-hmm.
Can you talk to us about what those credits are?
Sure. So you have the scheduled reimbursements, which are the fingerprinting. Your applicants, they get fingerprinted, and then you have your unscheduled reimbursements, which is the investigative cost recovery. So when you settle, when the case is finalized, the judge may award you the cost of pursuing that case. And you never know what the judge is going to award you or if you're going to get an award in any given year. So it's those are very unpredictable things. So reimbursements aren't usually, they're shown here as basically almost like a credit back to your expenditures, but you can't assume you're going to get those dollars in that year, so you can't spend against it, if that makes sense. You can't say, oh, well, if I'm budgeted to get, 50,000 in, reimbursements, then I can spend 50,000 more. You can't spend against it, so it's a very unknown, you just bring in whatever you bring in, and it's kind of credited against what you end up spending.
I have a question more for staff to respond to. I see some charges for overtime that historically I don't recall on our senior board billboard. Can you explain that?
Excuse me, I can speak to that. This is Kathy Cooper. We have two staff members who were working with the last EO on a particular project. They came in on a Saturday, and they were allowed to do overtime for that.
Great,
That's
thank
what
you.
This is Kia Zamora. That project was for Breeze for R2 regression testing.
Thank you.
Okay, all right, I'll move on to the fund condition then. So the corrected one in front of you, just to outline what the correction was. In the 16-17 column, the revenue was off. So now what it now reflects is what is reflected in the 16-17 budget. And what we do is, for future fiscal years, we assume revenue remains consistent. And that's why you'll see that 17-18 revenue matches your 16-17, because the assumption is that you'll bring in the same amount of revenue in 17-18 to 16-17. So I just wanted to point out that's what the correction was. If you look at on 15-16, this reflects your 15-16 actuals, which is what we just went over on your expenditure report. So if you go down under expenditures, you'll see your actual expenditures is 1,049, and that's higher than what's on your budget report because you don't count your reimbursements in that, so that the reimbursements aren't shown. They're not credited against your expenditures on the fund condition, so that's why it's a little higher than what you see in your budget report. And then if you go up higher to revenues and transfers section, you'll see you brought in a total of $989,000 in revenue, which was higher than what was projected. So you brought in more this year, and it looks like a pretty significant increase from last year as well. And as far as future fiscal, so 16-17, 17-18 expenditures, that's assuming you expend your full budget appropriation. That's why it's so much higher than what you spent in 14-15 to 15-16. So 15-16, 16-17, your appropriation is about $1,511,000. So that's assuming you spend that full amount. And as you can see, you don't historically spend your full appropriation. You usually revert a significant amount. So that will probably, you probably won't end up spending your full appropriation again in 16-17. Any questions on the fund condition?
No.
Okay. If there's no other questions,
Thank you, Marina.
thank you very much.
All right, next on my report is the public education update. Dr. Nancy, would you like to talk about the committee meeting?
So the Public Education Committee met on August 17th, and with myself and Kathleen Cooper, Darlene, and Gary Duke were present at the meeting. The new website became active in March, and available data on how many people visited it and what pages they looked up and all that is not currently available, but the data as to the number of web licensing lookup hits for the calendar year as of July 6th has been made available to the Office of Information Services. So from January 1st, 2016 to July 6th, 104 inquiries were made as to the status of licenses for doctors of podiatric medicine, and the majority of the licensing were made in January, followed by March and February. Additionally, the statistical results indicate that there were 675 inquiries made as to fictitious name permits held by doctors of podiatric medicine. Now, since we are now having an interim executive officer, there was some, challenges as to how to answer some questions that sometimes led to, more complex routing around for their answers. So there's approximately 8 questions that were posed since June where inquiries were referred to appropriate sources, but inquiries that regarded significant clarification were sent basically a letter saying that Kathleen was our interim executive officer, and that the response will be forthcoming in the near future. So, and it was, I think, a good way to handle some of these inquiries. So there have been issues recently raised concerning protection of privacy rights of those inquiries on specific, perhaps identifiable matters, and the unauthorized publication of same. So as those questions come up, we will continue to do the best we can with this sort of process. Now, the next...
Hold on,
Yes.
Judy. Two points. Number one, you raised an issue about the privacy rights of the inquiries and not identifying those people. Is that a concern, Gary?
Yes, it is.
Okay.
In fact, there's an old case, Black Panther Party versus Keogh, back in 1974, I believe. But it raised the question of disclosure of complaining information, and it was decided by the court at that time that there would be a chilling effect, or a possible chilling effect, of people not wanting to make complaints because of the fact that their names would be, publicly available and all. So, yeah, no, we do have certain privacy concerns with regards to that.
I'm not sure. Dr. Mansdorf?
Well, last year, the board passed a motion that we publish our inquiries, and based upon the privacy concerns, that's quite an issue. I might suggest that we make a motion to revoke that requirement for us to publish these issues until we can come to some better solution about how to inform the public.
Well, it's certainly possible to publish inquiries, but in still protecting the privacy rights of the complainant. I mean, when the board, I wasn't counsel at the time, but when the board made that decision, did you actually publish the names of the?
No, that was redacted. Any identifying information was redacted, but it still may be better practice to screen and kind of cleanse how things are published. We still want the public to be informed about what's being asked and how the board decides upon it.
Right.
But I think there might
Well,
be.
I guess it comes to a point as to whether or not the additional information you have, would explicitly, point to an individual. And because I totally understand the concern and the need for publishing those kinds of things. You have a certain kind of fact pattern, which may be replicated, I guess, in many different forms, and so you want to address that kind of an issue. On the other hand, we do want to protect the privacy rights of the individuals who are actually complaining. So I guess what I'm saying is I don't necessarily have a problem with the prior board policy, so long as we are protecting the actual individual privacy rights of who's ever complaining. So.
There may be issues not just with their names, but the hospital identifying information
Yeah, I
within the
understand.
question that could actually identify the individual or the facility.
Right. Yes.
So
Right. I understand that.
I don't know how the mechanism would be to edit out all that information.
The motion was a requirement that we publish, and I might suggest that we revoke that, but kind of editorialize what the questions are and inform the public what's being asked.
I don't think that would be a problem whatsoever, and that can go before my office for review in order to protect the privacy rights. And you're right, there may be additional information where, well, you can pretty much surmise who's, making the complaint.
So my motion would be to revoke last year's proposal that we publish all inquiries to the board of or from the Board of Podiatric Medicine, and that our goal is to still inform the public. We'll still list an editorialized version of the inquiries, but striking all identifiable information.
Do we have a second?
Second.
And that the motion, specifically the date that he was talking, Dr. Mansour was talking about, is on September 18th of last year, for clarification. Any further discussion? Any public comments? Okay, let's vote on Dr. Mansour's motion.
Mansour, aye.
Christina Dixon, aye.
John Shaw, aye.
Judy Manzi, aye.
Dr. Zaff?
Michael Zapp, aye.
Okay, that motion passes. Okay, the second portion of that is the, I understand the letter going out to the inquiries that required complex decision-making, but how are we going to deal with some of these inquiries?
So, historically, there are answers to many of these questions, correct? As I understand it. And so, not being an attorney, I certainly can field the question to a point. Sure.
This is Kathy Cooper. There is a plethora of answers created over the 25 years that Mr. James Rathberger was answering these questions. And then there's 2 years of these questions being answered by Jason Campbell. So I do have resources that I can rely on. I believe most of those answers are in agreement with each other. If there are conflicts, I am willing to perhaps, if it stays within this committee, to consult with the members of this committee, or if it moves to a different committee. But for the most part, I believe Jim's long tenure created so much of a resource for me. If you guide me to follow that, I could do that.
You have access to all of his emails and his interpretation, both Mr. Rathbosberger and Mr. Campbell's?
Yes, your very competent staff has kept those, and I have access to those.
Okay, and I would imagine that would be a main reference on how to answer some of these questions. And then certainly you have the resource to ask any board member that you seem fit about additional information that may be sought. Because we certainly don't want these inquiries to keep building.
I have a question. How is that information currently housed? Is it paper copies? Is there a database where we can easily query responses based on subject matter?
Well,
And if that isn't in effect, can we look into getting something like that in place?
Thank you for that question. The format of which it is in right now is strictly electronic, and it is embedded in. It's an odd way. These are like emails mostly that have been saved and created in a document that it is our plan to access every one of them, print them out. I do believe there are privacy issues with sharing these emails, but the content and the questions themselves could be rephrased and put into a simple document to be reviewed by whoever does consult with me if there are issues. We also discussed at the committee meeting, Kia Zamora discussed the fact that we've historically used fact sheets, and that it's possible that we can create a new fact sheet with many of these questions in there with the proper answers. So guidance from this board would lead me to do that as well.
I'm just thinking that a database could be a great resource and a tool for the board. Because you can put that information in a database and be able to query it.
That's the plan. It is not currently in a searchable database where you can do term
Yeah, I'm
searches.
making the recommendation.
Thank you.
Also, the other thing that I know historically have been done is when the executive officer comes up with his or her interpretation, that they were in the past able to send a unilateral email to each of the board members on their decision so that each board member could be informed. These emails are not bi-directional. These are only for informative purposes. And I don't think there was an issue with that, correct, Mr. Duke?
Yes, provided that it does not instill any kind of conversation between board members. So it's a unilateral, like informational and kind of discourse that's not a problem in terms of the Open Meetings Act.
So the comments may be made directly back to the executive officer, if you have one.
Yes.
As a board member, but not between.
Not between board members and not for the executive officer to disseminate any information of what other board members had said. So as long as it's going one way, both ways, that's okay. That's in compliance with the Open Meetings Act.
The next thing to discuss is the newsletter. So we had been talking about a newsletter for a while. We finally have sort of a hard copy of one. We're gonna eventually try to do this quarterly. Right now, we're trying to get this one done for October, and I'm gonna pass one out to everyone. This is just a rough draft of it, but it shows you essentially, what would be in it. I want to thank you, Kathleen, for getting, and the staff to making this happen, because this has been a long time coming. I just want to say something really quick about it, though, and that is, why this newsletter and what are we thinking about in this regard? To have a presence, I guess, here, it's not a bad idea to have something like this around the Capitol. It gives us some visibility and maybe answers people's questions that they may have about who are we and what are we doing here. With that being said, it's a tricky thing because I think it serves both the podiatrists that we represent and both the consumers of California. So the essential subject matter stays sort of on that line. And so when you're thinking about what should be included in it, keep that in mind. We really do encourage all the board members to please, if you have any ideas about this and what you would like to see in it, please let me know, because as you know, my committee is very small, and I would appreciate your update or your input on this as well.
This newsletter is going to be on the website also.
Yes.
Okay.
I just have one suggestion. Just with regards to the pictures, if we can just be a little bit more diverse in the skin tones. You know what I mean?
Absolutely. It's a great suggestion.
Just wanna show a little bit more diversity. But it looks great, thank you.
I would just like to thank DCA June Vargas and her staff who really did the bulk of this work. And I'd also like to encourage any stakeholders or board members or any licensees listening to this to feel free to contribute a copy, which may or may not be accepted, but please feel free to contribute a copy.
Finally, we have the cures update. So, as we know, as of July 1st, 2016, all licensed doctors of podiatric medicine were required to register with cures. So, as of May 2016, we had BPM had 325 registered users, and as of July, that increased to 782. Additional information and frequently asked questions regarding the use of cures systems may be accessed by our website. The quarterly calendar.
One question, Dr. Manzi.
Sure.
I know that, it seems here that as of July 15th, there was only 782 registered users out of our licensed population of close to 2,000.
Yeah.
So that's a pretty low registration rate. I think ultimately it may be a good idea for us to have some type of letter sent to these individuals. And I'd like to hear from the board members what options, a friendly reminder, do we want to send, and if they don't respond, a letter of public reprimand or a cite and fine eventually. I think we need to have a policy of, number one, having all doctors of podiatric medicine registered, and then the second issue is compliance. I know you can't just register, you need to check when you write for these narcotic medications.
If I may, Kathy Cooper, I believe that the statistics that we received from the Cures Department may be delayed, because when I did the analysis of the finances, we had over 1,000 registered people coming in with their $12. So I know that might have just been an error in the timing of when we cut off the report from the internal Cures department. However, I do think those other 800, and I'm sure Key will discuss the licensing numbers, they're actually up, so we can expect to get more next year.
So how easy is it to identify the delinquent?
Thank you for that. Kia created a report for us this year that we looked at the delinquent. Many of them are retired, and they're just not paying that $12 to get into a retired category. They're showing as delinquent. So a letter or something like that may help get our numbers up. It's a great idea. If you want us to do it, we maybe Kia can comment on that.
Maybe some sort of a letter that even if they just have to respond to us. Yes, I'm going to do it. No, I don't intend to do it, type of thing.
Yeah, I mean, eventually if they keep, that's fine, an initial letter saying that you have to register and you have to be in compliance. Or if not, then future cite and fines may apply. But I think we need to have some type of policy that deals with those doctors of podiatric medicine that haven't registered and haven't complied. It's one thing to register, but you gotta actually comply.
This is Kathy again. What I'd like to suggest is that we prepare this for the next board meeting, some type of report to see if we can get these Cures registrations up.
I think it would also be helpful to have the regulation and what the regulation requires, because that's what we would hold our professional members to, is to be in compliance with the regulation.
Thank you.
Well, the compliance states that you have to check the Cures database before you write for a narcotic, and then you have to check it every 4 months.
They have to be registered.
Yes,
So that's
first.
what I'm saying. I'm talking about the regulation as far as what it requires of the professional members with regards to Cures. So, I mean, if we're reminding them the regulation or the law states you must do X, Y, Z, I think that's what I'm saying we should be including in whatever notification we send out.
Correct. That's, number one, that they had to have registered by July 1st, and that they need to check the database before they write for a narcotic and check it every 4 months. I think those are the specifics, and I think that should be included to make sure that every DPM is in compliance,
Right.
not just registered.
Right.
So do we want to send that letter now, or do we want to do more research and wait till the next board meeting?
I suggest we just bring this over to the licensing committee report, which is about to happen in a second, and see if Kia has some insight into how we should handle this.
Okay. We'll put this on the agenda for the licensing committee. This topic to come up with some type of policy regarding adherence to the Cures update. For Cures, excuse me. Dr. Mancy, please.
So then I'd like you all to look at the calendar, the quarterly calendar that shows our next meetings here. So October 29th would be the staff. And then as far as the committee meetings go, we would be seeing each other again on November 9th. And then our next board meeting would be December 3rd. So those are busy times of the year, so everyone be sure you've got that marked.
Next on the executive's report is licensing committee. Kia Zamora.
Please enter your meeting ID, followed by number sign.
Voice change, Kia.
Okay, I don't really have anything new to report, aside from what's in, the report. I guess just, if there's someone that would like to approve.
Kia, I don't mind elaborating more on this since I was on the committee. As far as the licensing statistics, we're still averaging about 70 new licenses a year. The last fiscal year, we had 79, the year before that, 70, year before that, 69, 66. So the numbers of new licensees has remained relatively consistent. Breeze update, it's up and functional. The renewal portion of it, I believe, is still not ready. Is that correct, Kia?
Yes, correct.
Okay. We have a continuing education CME audit. We're auditing 112 candidates over this past 3 months to audit their CME credits to make sure they're in compliance.
You have failed to enter a meeting.
With the June 2016 APMLE exam, we had a 90% pass rate, which has been consistent with the past. Proposed legislation that affects licensing, SB 1155. This bill would have required fee waivers for applications to honorably discharge vets, and have been in compliance with that. I don't think we've had any cases so far regarding that. Another bill, SB 1348, requires each board to apply military experience and training to licensure requirements, and the board has been looking into that. It's difficult to equate military experience, and we have yet to have a candidate request consideration of the military experience. Our board of the quarterly calendar for the licensing portion is included. Next item that was discussed was 2 new CME credit application. Both of them were recommended for passage by the licensing committee. The first one is MD trials. This would promote clinical trials in podiatric medicine. It's a 2.5-day training program plus 12 modules, each one containing 1 to 2 hours online, and they're seeking 25 CME credits. Their application is attached, and has everyone looked at that?
I have a question as to why it was submitted on the 5th of February. It was received on the 11th of February, and we're only looking at it now.
The MD trials, that one was the one where we wanted clarification as far as why they wanted 25 CME credits. They weren't clear as far as what justifies the 25 CME credits. And so a letter was sent to clarify that specific portion.
Historically, they had been offering this program before, but at 20 units, or was I misunderstanding?
I don't think this is a new trial. I don't think this has been ongoing, so this is a new application. But based upon the 2.5-day training plus the 12 modules at 1 and 2 hours each module, it seems to justify 25 CME credits, and that's what the licensing committee moved to pass. With that, do we have a motion to accept MD trials for approval of the continuing medical education program? Do we have a second?
Mansdorf, second.
Do we have any further discussion? Any public comment? With that, let's vote to accept MD trials for passage.
Gail Mansdorf, aye.
Christina Dixon, aye.
John Shaw, aye.
Judy Nancy, aye.
Michael Zapp, aye.
Okay, that motion passes. The next CME program is from O'Connor Hospital Wound Care Center. This is a 1-day seminar that involves 5 CME credits. It's approximately 7 hours long. They sent their curriculum in for that one-day program. All the other paperwork was intact and in compliance, and the licensing committee voted to pass this CME program. So I'd like to make a motion to accept O'Connor Hospital for passage of the continuing medical education program. Do we have a second?
Second. Judy Nancy, second.
Any further discussions? Any public comments? Dr. Mansdorf, do you want to start off the voting?
Neil Mansdorf, aye.
Christina Dixon, aye.
John Shaw, aye.
Judy Nancy, aye.
Michael Zapp, aye.
Okay, that motion passes. And the final topic under the licensing program is the Board of Podiatric Medicine current and proposed unscheduled fees. These were the service fee increases that was to be included that this board passed last year. And this basically, the service fee increase was an attempt to have the actual fees incorporate the time spent. These fees haven't been changed in some 20 years. This was not included in SB 1039 since all podiatric references was removed. So this service fee increase may have to be introduced in the future in some other form, maybe at our next sunset review. I think there was one other issue with that, was the ankle license fee. Under the old program, under the old service fee, excuse me, there was a ankle licensing fee. That ankle license is now has been removed, and so I think there was some confusion of how we're going to eliminate that ankle licensing fee. Has there been any updates with that, Kathleen?
Kathleen Cooper, what I'd like to mention about the fee proposal that was brought to you last November 2015, you voted for all 8. Well, if you look at 6 and 7, I believe they was erroneously included because you don't give those exam or appeals anymore, and we would like to eliminate that when you revisit this. The other issue on this that I'd like to revisit is we can get legislative authority to go as high as you wanted for those fee increases. However, it might be possible or more palatable for our licensees for some of these that if we get authority up to that amount, however, don't increase it right away, from $30 to $100. We could get legislative authority if we're lucky enough next year to receive these fee increases. We then would just make a regulation to eventually ease into those higher amounts rather than, just jump so high at one point. So I'd like your input on that, but this will be an item that we bring back to the board before, probably in November, to approve again to see if we can get this next year.
I think the board passed a motion to accept the service fee increase as is. So do we really want to change the fee amounts?
I have a question. So if we're still considering the proposed fees, can we just make sure that we've included all potential fees? I mean, is there anything that we missed off the list?
Ms. Dixon, when I prepare the item, if I do prepare it in November, I will make sure that any unscheduled fees are included. These are all fees except for your renewal, your license renewal. That's what we call unscheduled. And so I'm hoping that I can give you a full report on eliminating 6 and 7 and perhaps checking if there's something we missed. At this point, I do not believe there's anything we missed.
Okay, thank you.
Okay, any other questions regarding our service fee increase?
Well, my question would be, there's a notation on the first paragraph issue where it says Senator Hill indicated that the fee issue would be handled next year within the sunset review process for the Medical Board of California, which makes no sense to me. Ancillary fees shouldn't have anything to do with MBC.
If I may, this is Kathleen. The 1039 bill was, we'll get to it later in our board meeting, but originally included these fee increases. and all language referring to the Board of Podiatric Medicine was removed, and including, unfortunately, the fees as well. Senator Hill specifically stated that this will be revisited, and that is the authority at which I wrote that paragraph. And it's, we can go to YouTube and look at it because it's right there, and so in other words, because we are part of the medical board right now, it's within their jurisdiction during their sunset review to revisit the issues that came up in 1039, and judging by what Senator Hill said, I am preparing for that, and the report will be available on December 1st, so we're awaiting the medical board's report and to see what it does include about podiatric medicine.
Okay, any other questions or comments? Okay, next we'll go to the enforcement program update. Dr. Mansdorf, do you want to take that?
I'll share this with Bethany. Unfortunately, our committee was unable to meet due to lack of quorum, but our enforcement coordinator is here. I'll have Bethany DeAngelis expand on it.
I'll send you a brief overview of the statistics, and we're looking pretty good overall. Complaint investigation and disciplinary data continue to improve and get closer to DCA targets. This is despite the fact that we've had some staffing issues, mainly within the investigation area. At medical board, we had a vacancy in the individual that processes our complaints for about 6 months, and we are now completely caught up with our desk investigations thanks to Julie Brown, who is here today. And also within the Division of Investigation, they're experiencing large staffing shortages throughout the state, which means their investigators are carrying heavy caseloads, and it may cause some delays with our investigation closures. Again, despite this, we are creeping closer and closer to DCA target numbers. I did also want to mention that between my quarterly reports, there are sometimes differences in the numbers reported from the last quarter into the next report, and this is due to a lot of variances, sometimes delayed entry of information into Breeze. Sometimes cases are reopened, so the numbers may be off, 1 or 2 if you notice a difference between, a quarter 2 report, and then later when I report on quarter 2 again, the number may change, by a couple of numbers. But it's a overall snapshot of the enforcement program and as close to accurate as we can get at any given time. If you look at the Attorney General case aging data on attachment E, it's looking really good. Our cases are closing. The most aged cases are dropping off. And, our numbers are looking really well.
Is joining the meeting.
As far, I think that's really the only important information regarding statistics. Is there any questions regarding the numbers at this time?
Yeah, actually, unfortunately, we hadn't been able to meet for subcommittee. There are a few corrections that we need to make for the permanent record. On attachment B, under desk investigations, second line investigations completed for quarter 4, you list 46. Over last year was 26. So that's actually an increase of 115%, not a negative 32%.
Investigations completed under quarter 4.
So we have 56 total for this quarter, 26 last quarter, and it says minus 32%. It actually went up 115%. Attachment B.
I'm looking at it, and mine doesn't seem to match yours. I'm showing on that line investigations completed for quarter 4 at 52.
Are you looking at the top section
Is leading the meeting.
for desk investigations?
Oh, I'm looking at the attachment B on my packet is the full year.
Yeah, B is in boy.
Oh, well, 56 over the 26. statistics.
Yeah.
So correct the statistical difference.
And then on the next attachment, it's not labeled, but it's the one following B. For case investigation aging, if we look at the total, or the Q4 total, and you see the number of cases aging, and you compare that to the prior year, the numbers seem awfully low. I don't know if that's an average, because there were actually more complaints last year. I think 150 total complaints received. And I know over that last quarter they had to be higher than the numbers listed. So we may just want to take a look at
Check
those numbers again.
Yeah, no problem. I'll check that over last year to see if there might be an error there.
Thank you.
Any other questions on the enforcement statistics? Okay. Then I'll move on to the probation cost recovery status update. Q4 brought in $5,544.94 in both cost recovery and probation monitoring. Not a high number, but this is pretty consistent with Q4 averages, which normally are around $6,200. The total year's cost recovery and probation monitoring collections were $47,000.61.24. This is quite a bit lower than what we normally receive, at least comparing over the past 4 years. I believe that this is due to there was less cost recovery ordered this past year, and also there have been quite a few probationers that have been losing their licenses and having subsequent discipline and are just unable to pay their costs. So our recovery of these costs has gone down. Item C, the consultant and expert training update. Consultant training took place June 24th in Anaheim, and all of our consultants are up to date with their training per board policy. Expert training is offered through the medical board, and we have 2 new dates coming up, one on October 8th in San Francisco and one November 5th in Los Angeles. So far, this information has been forwarded to our experts, and we've only received 1 response of someone wanting to attend out of our 34 experts. Medical board does not require their experts to attend this training, although they highly encourage it. This is something we're going to be talking about in the next item as far as expert training and review. So it might be something we want to discuss further, and requiring our experts to have training could be slightly problematic. If they don't appear, then maybe we're going to be very short in our pool of experts for conducting case reviews. And it's a really important job that they have, so we might want to look into other options getting our experts trained. They are all provided with a binder of information on expert guidelines before they begin. And the last training that we held was in 2011, but now we've kind of consolidated it into the medical board training program. If there's a way to provide incentive to get our experts to attend this training, that's something else we could also look into. Also, we met with Solid this summer in order to try and develop an online training module for both our consultants and experts, which would make it a lot easier for all of them to get their training and not have to appear at a location somewhere in the state. So this is something we're hoping to have developed and ready to go sometime next year. Any questions on the training?
So with the expert training, is it suggested that they attend? Do they have to attend so many trainings over the course of a year? How does that process work?
It's purely suggested. Now they have criteria they have to meet in order to even be an expert. So we are picking from, I guess, the cream of the crop. Have additional certifications, so much experience, not have any negative disciplinary actions or investigations ongoing. But at this time, we don't have a requirement for them to have a specific training in place. Our experts are used a lot less frequently than our consultants, who see almost every case, and the experts only get the ones that are, have major departures and need additional review and to go to field investigation. So many of our experts on the list have never even seen a case. Therefore, it's having them go to training, paying for that, could be kind of expensive for our board, especially if we're not using them very often. So these are all things to consider.
Is there any way that these experts can be picked from the pool of consultants?
They have two different roles. So the consultants have a much heavier workload. They're reviewing cases every month. And also, they don't get paid a lot per hour. So getting people that want to do this work and spend that much time, I think that's where some of the difficulty is on top of their full-time careers. They're taking on extra work for, to pay $75 an hour for a consultant, between $100 and $125 for our experts. Where was I going with this? Repeat your question one more time.
Just that, so we don't have enough experts, or?
We have enough experts at this time. I think part of the concern is there were some reviews that have come back that caught the attention of board members saying they didn't agree with the way they did their report and commented on certain scope of practice issues and how could we get them better trained. Most of the training is not going to go into scope of practice issues, it's going to go into the procedures themselves legally in report writing. Scope of practice, that isn't something that we train on. We're hoping that they can pull on their own knowledge and their own training and resources to come up with the right information to write their responses on the reports. So the training, and again, is just going over the process and getting well-written reports that our attorneys can use to build good cases. As far as what the content that they put into their reports and the scope of practice issues that are coming up, I believe that was something the board was concerned with, that maybe some of the information they're providing is not consistent with the standard throughout the state. I do know even in doing the consultant meetings, sometimes there are slight differences in how people view a scope of practice and what is, standard care. So they're human beings, there's going to be some slight differences. I don't know how to entirely control that.
So I have a question. So when either a consultant or an expert comes on with the Board of Podiatric Medicine, how do we onboard them? Do we give them, our ideas around how these things should happen, or are we just leaving it up to them to use their own discretion?
We have a manual that is provided to all of the new individuals that kind of go over their roles and responsibilities, give sample reports, and kind of explain the whole process for them. As far as the personal research they do to come up with whether or not somebody is in violation, that's not something that we provide training in. If they have questions, they should, ask their resources. Obviously, not talk about any case they're involved with, but they can talk to the attorney, the investigator involved. But yeah, as far as specific scope of practice related issues, there isn't anything provided to them there. The last time we even hired experts was back in 2011, so we haven't hired any new experts since then. And so no new materials have gone out.
So other than, the annual trainings, do we engage with the experts that are in our pool throughout the year?
At this time, only when we have need of their assistance with a case. If there is additional information that the board would like to have go out on a certain yearly basis, or that is something I'm sure that we could put together.
If I remember correctly, board members had hoped that it wasn't necessarily training, but that there could be discussion after a case had closed amongst experts to review closed cases and discuss the approach their interpretation and whether other members might have felt the same or taken a different tack. So obviously it's nothing you can discuss during an open case, but that there was some back and forth amongst other experts to, if there were a scope issue, that they could see there's other interpretations.
Right, I remember the discussion. I wasn't sure exactly how we wanted to address the possible review of expert opinions that have been provided after a case is closed. So this is something possibly within the enforcement committee that we can discuss and decide what type of guidelines we want to put together for conducting reviews, as long as they're legally acceptable. And that's why I brought Emily here today
the Deputy Attorney
answer some
General.
of those questions.
That's not a problem. Other boards have actually done that, particularly with regards to closed cases, to figure out if the board was being consistent, and also to determine, at least with one of my boards, they were very concerned with the cases that had been dismissed, and wanted to know, well, was it valid and everything, but yeah, that's not a problem, particularly dealing with closed cases, for board members to be involved, directly in reviewing those kinds of cases, after the fact, and also, I mean, that's actually a really good idea, I think.
Yeah, but it's not a requirement right now.
No, not at all.
And trying to get them to sign up for training also appears difficult.
It can be. I mean, if the board wanted to put, something, a directive, if you want to be an expert, you're required to attend something within this amount of time and however many years, I'm sure that's something we could do. Again, my concern would just be that these individuals may not show up for training and then we're losing experts in our pool. But we could also do additional recruitment.
Well, I mean, I think, given the nature of the work, we want to make sure that anyone that we have in our expert pool is on top of things and consistent and in alignment with what we would expect of an expert. So at this point, it sounds like once an expert, always an expert. Do we ever go back and have them recertified to be an expert, or once you're in the pool, you're in the pool? I mean, that may be something that we need to look at, because they may need to recertify after so many years, and then a part of the recertification is you must attend a mandatory training.
Right. At this time, we have more requirements for our consultants than we do for our experts. We could put together something similar to what we require for our consultants.
I mean, I think that would be appropriate. I mean, given that, when I think of an expert, I'm thinking of someone who would be held to a higher esteem than a consultant. Do you know what I mean?
Mm-hmm.
So I think we definitely need to look at making that a more robust kind of process.
At this time, the review process on the expert and consultant work is fairly informal. I do get feedback regularly from different attorney generals and investigators that work with them, and if someone comes back saying they did a very poor report or this was problematic, then I just I stop using them, and that's what I'm doing right now. If we wanted to put together something, a more formal review process, I have no problem with that.
But do we give feedback to them when they do a poor report? I mean, is it kind of like let's chat about what we didn't do? Do we take them off the list?
With
Are
the
they no longer
consultants,
used?
definitely. I've gone back and given some feedback and suggested where they can improve. With the experts, not so much. I've kind of just gone through the guidance of the prior EOs, and they just basically said stop using them.
So do you have a need for consultants and experts at this moment, or not?
At this time, I'd say we could probably use a couple additional consultants. Our expert pool is pretty good, and it handles our current caseload, which is not that heavy. I don't think it would be a bad idea to advertise and get more into both groups, especially when we're looking into this next subject on our EEO goals that we have. That it wouldn't be a bad idea to get some, fresh blood in, and maybe have a new way of administrating the program.
Ms. Brinkman, did you want to add something?
Well, I think and the topic that you have for the next agenda actually rolls into, this is very related. And so I just wanted to let you all know that part of the Deputy Attorney General's, what we're doing is when we're closing cases, we want to make sure that when we've used an expert, we do reviews. So we have a form right now, we're using a medical board form, but we've asked the DAGs to actually return them to Bethany here so that that feedback from those attorneys it's getting passed on. So that if there is a bad expert, they can get taken off of the list. So we're trying to make sure that that's employed statewide within our section. Bethany and I have discussed about updating the form specifically for the podiatry board so that if there are additional issues or concerns that the board wants addressed on that review form to make sure it happens. I can also tell you that as an attorney, when I work with an expert and if I'm seeing problems within a report, often we have to talk to these experts when we're preparing them for trial and, next time you write a report, try not to use this kind of language, those sorts of things. So education does occur with those experts as we're working on a case. So they are getting some feedback from attorneys as they work on cases.
Does that conclude your board, or?
No, I just
sorry.
wanted to, I didn't know if you'd gone on to the next agenda item, so I just didn't want to.
Right.
Thanks
we
for
were
that
talking about the
clarification.
training, and now it's kind of a crossover between the training and recruitment of our consultants and experts. So we can roll into that segment now if you'd like.
Okay.
So this is Kathleen Cooper again. I'd like to formally introduce Emily Brinkman, who is our DAG.
Hello, good morning. So I think one of the big issues for experts that has been hit on today is training. We really need to make sure that these experts understand what it takes to write a good report. I know there's concerns with standards of practice, but those are always going to change. They're evolving. So it's really hard for us or the board to set aside training every so many years to include standards of practice. But if we work with these experts on how to provide a good and well-written report, that helps us, I think, in the long run. So I think the board needs to make a commitment to that training, whether it's requiring them when they come on as an expert to undergo some kind of training, whether it's a web-based training, whether it's the in-person training that's done by the medical board every few years, or we set aside some time to do our own specific training. The board currently has expert reviewer guidelines. Is there a way to make sure that the experts are in fact looking at these guidelines, using these guidelines? There are sample reports from closed cases, good and bad. Bethany and I have actually updated some of those recently for the medical consultant training so that we can shows how the reports have changed over the years. So keeping those reports updated, those examples updated for those experts, but requiring them, sign a form. Yes, I've read these guidelines. I understand what it takes to put, what is required to put into an expert report. So I think that's the biggest step. Now, how the board wants to review experts and their work, I think Mr. Duke was correct in talking about, once the case is closed, whether it's the enforcement committee meeting and looking at expert reviews, whether it's looking at the DAG evaluations, and having those discussions, or is there some kind of peer review that you have with the medical consultants? I mean, there are some ways to assess whether these experts are doing a decent job. I mean, there's lots of different ways to do that. It's just a matter of what the board really thinks is most efficient and for their purposes. So there's lots of options that you have to review these reports. I do know that we are trying from the Attorney General's office to make sure that those reviews are getting turned in on closed cases. I think it really helps Bethany out. The problem is, though, there's very few cases that I think there's 9 open admin cases right now with the Attorney General's office. So not a lot when you have a pool of 30, 40 experts, and maybe, we're only seeing 9 of them in a year, or 2.
Yeah, out of our 34, there are a few, as I said, that have never even, touched a case, so not all of them are used or available when needed.
When we get the summary of, the stipulations and, we read through what the expert has written, the consultant, that's the consultant, or is that the expert?
It's usually the expert at that point. The consultant does a preliminary review and then suggests whether it should go for further investigation. An expert will do a more thorough review at that time.
Right. I mean, I think I can tell the difference in just those few cases that I've seen come across here, and just by the way they're written. I did it years ago, and the training was done years ago as a consultant and then as an expert, that I actually had to participate in a court trial. So, so I've kind of gone through the entire process, and I don't see how you could, the need for the training is huge, because just to write it properly, it's the language, and I think the big deal is that it's either, you don't have to make a comment so much as whether or not it's below or above the standard of care, and then take it from there. I mean, you may have different interpretations, but whatever's in your area and in your neighborhood and what you know to be the standard of care, you may not practice that way, but so I think that I'm not sure though what you guys are asking. Yes, you need more consultants and experts, or yes, you need more consultant and experts to come to training. I'm not sure what you're asking.
Our consultant expert pool at this time is handling our current caseload. I think that there's more of a concern with getting a more diverse candidate or pool of consultants and experts as far as our EEO goals, and also with their training. So it's not the number that we have at the moment.
So it's diversity.
Diversity and training is the bigger issues that we're looking at.
I think there's always going to be somewhat of an issue though with the podiatry board too, though. You have a very small pool of licensees to begin with. So that makes it a challenge as opposed to the medical board, whose numbers are so large. And the areas are much more diverse. So it is a little bit difficult when you're talking about setting higher qualifications. Not that I'm not suggesting you shouldn't set higher qualifications for your experts or your medical consultants, but if you're looking at, you want to have the cream of the crop, which you should, but if you're looking at changing those expert qualifications, making it harder, we're shrinking that available pool even more. So it is something to be aware of. But I just know from my last appearance before the board that there had just really more concerns about how do we make sure that we have quality reports that we're basing the cases on. So.
Well, historically, this is
Question?
Dr. Zapp.
Go ahead, Dr. Zeff.
I think the reports are fine, but I'm a little concerned about the judgment of a couple of the reviewers on what they define as the standard of care. And it seems like it's a very individual definition that the average podiatrist, and at least those of us on the board, did not agree with. I don't know how to prevent people from having their own opinion and citing a podiatrist and saying he's beyond the standard of care when it's something that only that person thinks is outside the standard of care.
Well, that's part of the administrative hearing process too. So, we present, I'm not a podiatrist, so I get the expert reports as the attorney. I look at them, and this is what they have said, this expert has said is the standard of care. We go to hearing. The licensee has the opportunity. They bring their expert, and most often these cases are battle of expert. What is the standard of care? So that's the purpose of this process. Now, once it gets to the board for review, if it's something that's gone to hearing and you're dealing with a proposed decision and you're not, and the board doesn't agree with the proposed decision, that's when we go into the non-adopt procedures. I mean, there's a process that the board has when you don't agree with the proposed decision. And same with the stipulated settlement. The board has options. You don't have to accept decisions or stipulated decisions. But each case is different. And the board also isn't looking often at the entire case. They're not looking at the whole record. They're not listening to the testimony like an administrative law judge did. But that's why this process is in place, so that both sides have their opportunity to present that evidence on what that standard of care is.
Okay.
If one particular reviewer is consistently different than what the average podiatrist believes, do we have to keep that person as an expert reviewer? Is there any review on the reviewers?
Well, I think that was some of the questions that were brought up today. After that case closed, is there a way then for the board, whether it's through the enforcement committee or the board as a whole, to look at these and at these reviews and say, this is not something that we agree with and this expert shouldn't be a expert? That's totally within the board's ability to do. So on a closed case, absolutely. So that's information that can be conveyed to Bethany so that that expert comes off the list.
Neil Mansdorf, I think it's worthwhile then that some of the closed cases we can bring before the enforcement committee for review.
And then I would also suggest that we look at creating maybe a minimum requirement for continuing medical consultants. I see that for attachment A, it's for new, but do we have any standards for continuing? And then that can help provide some guidance for what we expect. I mean, because on attachment B, there's, if you look at 3, 4, and 5, there's some action that we're requiring them to certify things for the consultants, but I didn't see that for the
Right, there's nothing in place this time for the experts.
And one option could be having them review a closed case annually or every 2 years, or go to a live training session at least every 2 years, so that if they cannot travel, at least they could review some of the closed cases. But I think I agree with Christina's point, is that they should have continuing education, or at least every year or two, maybe.
And maybe staff can come back with recommendations to the enforcement committee for consideration, and we can bring it forth to the full board.
Is there anything on the website that does point people towards this if they were interested in being an expert witness?
There was, since our website was redesigned, a lot of things came off, so I believe that is off the website at this time. It is something we could put back up.
Yeah, I think that would be a good idea.
And I know at one time the expert guidelines were available on the Podiatry Board's website as well, so that's available to everyone. So all licensees then can see what experts are looking at and putting into reports, so that it's not just something available to experts, but that they're out there for everyone to look at. So.
Yeah, I think that should be on the website, that there is a need.
I prepared an article for the newsletter. At this time, it's only asking for consultants because I think we have a greater need there, but we can include experts in that as well, and to possibly get applications from those.
The way it's being handled, Bethany, basically when an expert has some controversy, we tend to use that expert less. Is that a fair statement? Okay. And then we want to make sure that all the consultants are given equal number of cases, if possible. What is your mechanism to determine which consultant gets sent to what case? Is it their expertise regarding the subject matter, or?
At this time, it has more to do with who's available to take a case, because they kind of take them on a flow basis. Right now, Julie could probably speak to that, as she sends most of the cases out to our consultants, unless it goes straight to field investigation, and then if they need a consultant, they request it from me. But yeah, at this time, it's maybe where they're located in the state, where the case is, and then who has the availability. We only have 11 consultants right now, so it's kind of difficult to pair it up. And also, some consultants just accept fewer cases. Others can go through multiple cases in a month. They get it, turn it around really fast, they get it back to us. Others are on vacation or just say, no, I can't accept a case, or take me off for a few months. So as far as how many cases they each get, that really varies based more on their availability than anything else.
Okay, I think the subject matter should be important. I'm sure some consultants have different expertise. So if you have a complex ankle trauma and you need a newer consultant who's had the 3 years residency training, which is required now in trauma, that you could somehow gear that person toward that subject matter. If you had some type of diabetic foot amputation, you want to try to find a consultant who specializes more in wound care. So I think the subject matter should also be a consideration.
I think we could definitely pull our consultants and experts and find out where their specialty areas are,
Right.
And add that to a database so that it is something we can consult for the subject matter of each case. Again, because we have so few of them and it's a small community, they may not be able to take a case even if they're the expert because they know that person, personally, or have too many dealings with them. But definitely, we could probably put something together to get it a more smoothly running program.
Great. I mean, we want to use all the consultants. We don't want to just use the same one over and over, ideally.
Right.
So with those queries, is there a need for us to maybe update the questions we ask of the consultants when they're coming into the pool? I mean, maybe we just need to revisit that whole process just to see if we're capturing the right information that we need to be able to segment them out based on their expertise, availability, because your availability changes. So we would hate for you to call people that aren't available anymore because they didn't self-certify. So maybe we can incorporate into our process just checking in with them, periodically just to make sure that they're still available.
Yeah, I think we could probably develop a form or use the current application and add to it to get more information from them.
And once again, the certification would be that they attend this designated time and place certification venue, correct?
I think there's various ways we could do it, not only through attending a live training, but we also have materials that they could review and certify if they've read it. Expert training was videotaped at one time, so we could have more of the DVDs produced. They could watch the entire training as they're planning to appear in person, and again certify that they watched that and are familiar with all of the the rules and procedures.
I do
There's
think
a lot of options. Again, solid training that we're trying to develop,
Right.
which would be a online tutorial.
I do think that's a better way to go. I mean, I think that to try to get someone to go to one place at one day is not going to yield us a high.
Right.
Okay. Ms. Brickman, are you done with your presentation? Or?
I am, thank you.
Okay, thank you for your presentation. Very informative. And Bethany, are you done?
Yes.
Well, actually,
Or any other questions?
Are we leaving the enforcement section? Because there was some discussion about the podiatrists are getting board certified elsewhere than ABPS. Well, ABPS really doesn't exist anymore. So it's now the American Board of Foot and Ankle Surgeons, and I think we need to revise the policy decision minimum requirements for new medical consultant experts and examiners. It should reflect the current change in name.
That's exactly why I included it. And also, we no longer give examinations, so that could probably come off. Perhaps the enforcement committee at the next meeting could go over some of these changes and come up with revisions to present to the next board meeting.
I think that's a great idea.
Okay. So that'll be on the agenda for the enforcement committee to update the board certification. Okay, next we will go on to the legislative program update.
If I may, Ms. Dixon, the committee did not meet, so I will give the report. I would like to focus on 3 bills that are most important to this board. The first one is AB 2193, which was presented to the governor at 4 p.m. on 8/31, and that extends the operation of the Board of Podiatric Medicine to January of 2021. So that still needs to be signed, but it's in the right place. And most importantly, the full meeting that we had on June 20th relating to SB 1039, we were directed, the president and myself, to work together to see if we could support that bill. And it turned out that the references to podiatric medicine were removed, and we did provide a letter to the Senate, Senator Hill, showing our support with those amendments. And that was enrolled on the 2nd of September. However, it didn't have any references to the Board of Podiatric Medicine. And thirdly, SB 1478, which was enrolled on September 2nd. And that now means that we have an extra board position. We have a secretary position. And that will be as of January 1st. So I imagine this board will be preparing to elect a third officer after January 1st. Are there any questions about the legislation? If not, I can go on to regulation.
Sure.
Okay,
You know
so
what, let's, does anyone else have to take a break? We're gonna take a 5-minute break. It is 11:32. We're gonna resume at 11:37 in 5 minutes. Okay, we're going to reconvene the meeting at 11:43, and we last left off at the legislative program on the regulatory update.
thank you, Dr. Chalk. Thank you, Dr. Chalk. As far as the board's regulatory rulemaking packages, the oral argument had a hearing on August 17th, and there were no comments. We have received no written comments, so we're at the next stage, and I anticipate we will be tying this up before the next board meeting. That should be complete. So you'll be in compliance with Section 2336, which mandates that we have rules and regulations for oral argument. The second regulatory issue is the uniform standards for substance abuse healing art licensees. And Gary Duke, our counsel, and myself are working on that. It's quite complex, and we do have a first draft which will need to be edited by counsel, but we are progressing forward. Citation and fines number 3, that passed on September 1st. So we do have the authority now to cite and fine. There was a slight error. It was subsection D that somewhere along the line turned into subsection E, and we needed to do a section, what they call section 100, with non-substantive effect, and it did pass. So we are eligible now to do our cite and fining. And the last one, which is about acupuncture, should go pretty quickly once we file that. That has not been filed, but it will be shortly. I hope by the next meeting we can say that that is in progress. As far as the legislative calendar, the governor has till September 30th to sign those bills that we discussed that are on his desk. And as far as our next legislative committee meeting, looking forward, it will be on November 9th. And I don't anticipate us discussing any new bills, but perhaps we will be looking forward to our next year and the goals, our legislative goals for 16-17. Thank you. That concludes my report.
Kathleen, I had a question. With regards to number 2, I know you're working with legal counsel to finalize that. Is that something that will be presented and has to go before the board for approval?
Mr. Campbell presented the last version on November 15th of last year to you, and you approved it, and I'm working with that version. So unless some outside counsel tells us that things have changed since that time and we have to bring it back to you, we are going to go forward with the language you approved.
Okay, but will we get a copy of the final version?
What I'm saying is if no changes are needed, we can refer back to November of last year and see that is the final version.
So you're just working with counsel to implement whatever corrections or changes the board requested?
made at that time. yes.
Okay.
Yes, and I
It just
believe,
wasn't clear how it was written.
yeah, I believe you accepted Jason's version of how he wanted to present this. I do think there are other people involved that will have comments, and it's likely that you'll see it again.
Okay, I just wanted to make, because it didn't say that, so I just wanted to make sure that if anything changes, it will be presented to the board for it.
Yes, and if there are any comments that were made, it will be presented to the board.
Okay, so I just want to make that part of it.
No, you'll always have the final decision.
Thank you.
Okay, moving on, we're going to go to item number F, the executive management update. The executive management committee did meet, and we did have some discussion and consideration on issues raised by SB 1039 and AB 2193 and options available to the board. As we discussed, all podiatric references was removed from SB 1039. However, we were told that this item will be reintroduced at the medical board's sunset review in March of 2017. We don't know the details of that and which of the three major components of that. If you recall, the three components was to have us licensed DPMs, our board licensed DPM solely, the second being removed under the jurisdiction of the medical board, and the third, probably most controversial, being moved to the non-allopathic allied health section. So the board has had its concerns in the past regarding the apparent, there's no reason that the board sees that to change this time-proven, successful, effective formula that protects the public and provides the consumer with the ever-growing role of podiatric medicine. So we're trying to think of different ways to see if we could come up with something that could be possibly collaborative. I'm glad Ms. Huckle was here. Last board meeting, she presented some ideas as far as introducing legislation that perhaps could give our board the right tools to step out on our own 2 feet, and that's one possible avenue. Another avenue we can discuss is collaborating with the medical board and see if there's some type of compromise or some type of mutually beneficial legislation that could be produced from this. So if anyone else has any ideas on which way the board wants to proceed, please comment. But I think the main thing here is I think that introducing legislation to add some amendments, and the amendments that I'm talking about that was mentioned as an add-on to AB 2193, and the board approved of at the last board meeting. Specifically, there were 5 BMP codes that referred to 3 subjects. Those subjects being having doctors of podiatric medicine defined as physicians and surgeons of podiatric medicine. This is all an attempt to have the laws actually reflect what is happening now. And that's the whole purpose of why we were told that the medical board wanted to have us license our DPMs, because we want the laws to reflect what's happening now. So these amendments regarding DPMs defined as physicians and surgeons of podiatric medicine and attending physicians, and possibly some type of anti-discrimination clause, those items was removed from AB 2193 at the last minute. We were advised because podiatric references from SB 1039 were to be removed, that it was highly not encouraged to proceed with those requested amendments on AB 2193. So therefore, those amendments were pulled. Now, I think that perhaps we could talk to CPMA and see if they want to introduce legislation regarding those amendments. Excuse me. I feel that that's not necessarily our mandate or our goal, and I don't know if we have the resources to accomplish those amendments, but perhaps those amendments could be a compromise for if and when the medical board wants to continue their pursuit to split our board from their board. So if anyone else have any comments or ideas?
one comment I have is it may not be the board's job or, duty, I guess, to propose this bill, but it may be our job to protect the current status, being that we are not currently thrown into the group of allied health. And I do think that is sort of our job, to make sure that just doesn't happen. So, I don't think we can just totally dismiss that attempt.
I believe at the last board meeting, when we had Senate BNP staff who came and spoke, they offered, to provide some guidance. And I don't know if we've followed up with them on that. So I think, it's worth exploring all the options that are available to us as far as advocacy and how we can work with CPME and other organizations who could take up, I think we're limited in our scope of what we can do. And so we want to make sure that we're within our scope doing what we can do, and then seeing how we can work with others to do the other steps. So maybe it's, revisiting the discussion that we had at the last board meeting and then just following through on the suggestions and discussing it further, because I think we left it kind of with, open-ended with options that we can go after. So maybe we just need to pursue it further, have further discussions on the matter.
Yes, please, Ms. Huckle.
Good afternoon. Sarah Huckle with Senate Business and Professions. Thank you again for addressing this. This is very timely. You're correct. This matter about separating the board from medical board will be addressed in the medical board sunset report. They're working on that now. And legislation will likely be introduced in around the March period on this issue. Currently, it will likely reflect the last set of amendments from 1039. From the committee's perspective, we were never presented with a compelling reason to keep the situation as it was. The arguments that were presented as far as insurance concerns, as far as hospital concerns, we looked into those, and those were never something that were considered to be they weren't valid, basically. The medical board's concerns were more valid. They don't have any actual involvement with your board, so that was the committee determination at the time. We encourage you to either come up with different reasons to keep the board as it is, and work with the committee and the medical board, because otherwise it doesn't really seem logical given the structure of the rest of the DCA boards. As far as your fees are concerned, fees are not generally included in sunset bills. It hasn't been determined yet whether the Senate will have another omnibus bill like last year where we included fees for everybody, because to our knowledge now everybody has the fees that they needed, with the exception of your board. So you'll either need to find another author or talk with Bill Gage to see whether we're going to sponsor another fee bill. With regards to sponsoring legislation, other boards sponsor legislation all the time, so it's really within your discretion to do so on any topic that you feel fit.
One of the concerns I have is the desire to split our board from the medical board and remove us under the jurisdiction of the medical board. That's one issue, but then to put the field of podiatry in a separate chapter, non-allopathic medicine, is incorrect. Factually, what doctors of podiatric medicine do is allopathic medicine. Whether we're in the hospital working on reconstructive surgery, just like the orthopedists, it's the same modalities, it's the same surgery. Whether we're working on wound care with plastic surgeons or general surgeons, same modalities, same treatments. If it's dermatology and we're excising tumors, same as dermatology. No difference of standards, no difference of modalities or surgical technique. It's the same thing. That is factually incorrect to say we're not allopathic medicine. And that would be my biggest argument, factual argument.
And I agree with you, and I don't disagree that there are different standards in the care whatsoever, but this was from a formal statutory standpoint. It was not meant to be a comment on what you do or do not do. It was because the board is an independent board, you were going to give the board an independent chapter like the other independent boards. So, I encourage you to work closely with the medical board and also.
Pardon me, so what independent board do you suggest so what categorization do you suggest we go into? Because that's the wrong one.
The healing arts section is Division 2, so we place all the healing arts in Division 2. We don't categorize it allopathic and non-allopathic in those chapters. That's not something that we consider.
Any other questions or comments?
And Sarah Mason will be covering the sunset review of the medical board, and so she will be handling that area. So I encourage you to work with her on that specific issue, but I will continue to be working on Board of Podiatry issues outside of that sunset review portion.
I have a question. You mentioned the fact that the committee did not consider the various laws dealing with insurance companies and hospitals as being very important, but it really is because a lot of the requirements require a license issued by the medical board.
Right.
So why did the committee or you or whoever?
Sure. No, it's not that we didn't believe that they were important. We reached out to the insurance companies and we reached out to hospital systems to see if this statutory change would in any way impact practice, and they said no.
But the laws refer to a license issued by the medical board.
They said if it changed to be a license issued by the podiatry board, it wouldn't make any difference. And this is just
what are they going to change their regulations, the way their procedures are?
Apparently, we asked the people.
You took that on faith?
No, we have letters. If you give us alternate evidence, we will consider that. But with what we have, it was not determined to be dispositive.
So that means that hospitals would have to change their bylaws and their application credentialing.
Right, they didn't see that it would impact you guys at all, and I'm inferring that they implied they would do whatever was necessary to make that change.
Can we get a copy of these letters?
Oh,
yes.
Yeah, sure.
Also, did you take into consideration the way that the larger and less large HMOs function in the state and how their legislation and their rules and their regulations look at this? Like Kaiser, like Sutter, like all the other ones that hire a lot of podiatrists.
We contacted the California Hospital Association, which represents Kaiser and Sutter, and they're the ones that told us that this wouldn't be a problem. We did not reach out to insurers like Blue Cross and such, but we can do so. And again, anything you tell us that changes this discussion, we'll adapt to that. We're just saying that when you told us it would be a problem, we looked into it and we found out that it wasn't going to be. So there's no prejudice against this. We're just trying to align structurally with what other boards do. And if you provide us evidence that what we think will happen will not happen, we'll adapt to that.
I just think that the training and the education of doctors of podiatric medicine has evolved over the years, and we are factually physicians and surgeons of our field, and oftentimes we get legislation involving physicians and surgeons, such as a medical marijuana bill, and we're left out because we're not considered physician surgeons. But I think we're going to show you the physician surgeons our training, and hopefully you'll see that factually we are indeed physician surgeons.
Okay, and that matter would be separate from the separation issue. So that would be something that I would advise you to pursue independently. That's not something that's anticipated to be covered in the sunset legislation. And that would be a whole separate discussion with its own separate facts.
Okay, any other questions or comments? Thank you, Ms. Huckle.
Just one more question. I guess what would be persuasive? I mean, you stated that you have letters, from the hospital associations and everything, but again, my problem is well, not my personal problem, It's the law, refers specifically to license issued by the medical board.
Right,
When you
and-
take that out, again, there's already all kinds of hospital bylaws, insurance companies have their own policies. So I guess I'm just not personally persuaded by that argument, saying that there's nothing there.
We asked the people who would be dealing with this, and they told us it would. And the hospital systems representatives who answered the letter, I'm assuming, talked to their lawyers and their insurers and told us their answer based on that.
Well, they can change their practices and laws and everything, but the mere fact, though, is that existing law refers to a license issued by the medical board.
Right, and what we're talking about is changing that, because the medical board does not believe that they practically issue the license. They believe that you guys issue the license. So that would be the change in law.
Well, I guess what I'm saying is that I'm personally not convinced that that would be the case in the future.
What do you mean?
And perhaps maybe this board should illustrate or point out the various different laws and regulations from the insurance companies and or hospitals or so that require a license issued by the medical board. I mean, it seems like to me you're just taking upon faith that they say, oh, there's not going to be no problem. But there's not a lot of insurance here there.
Right. Well, it's harder for me to take it from you guys that it will be a problem for the people who say it's not going to be a problem for them. So if you'd like to convene some sort of a meeting between insurers and other people to discuss how this would actually work, I'm open to that. But right now, it seems to be that they follow the law as it is, and if we change the law, they'll follow the new law.
So why don't we change the law first, and then we'll agree to maybe something that's,
And I encourage you to work with the medical board on this issue. They're dealing with it in their sunset since currently you are under their statutory area, and then Sarah Mason will be handling that legislation.
Okay, thanks again, Ms. Huckle. Is there any other questions or comments regarding this subject?
I mean, it just sounds like to me we need to, as a board, devise a strategy that addresses the various issues, and then, think through them and present them. I mean, I think that's a part of what we're supposed to do as a board.
Correct. I mean, I still think that we still have some major issues regarding this proposal, and we'll get some further information, research, maybe reach out to the medical board and see if if there's something that could be done. But we'll revisit this, and I think we're going to have to come up with reasons why this is bad for the public.
Excuse me, this is Kathleen Cooper. Is there, when we were in committee, they said they were going to bring this to the board to direct your executive officer to start looking into what you're suggesting, Ms. Dixon, some type of beginning strategy or research, or see what the options are. And if you want me to participate with members of the executive committee to do that, I think you would need to direct me.
I think it's figuring out the appropriate committee for that to happen. And then maybe depending on timing, maybe it's having some sort of strategic planning session around this very topic. I think it's a larger discussion that needs to happen as a board with some guidance from, people who do this and have more knowledge about it than we do. So maybe that's the next step, is some sort of strategic planning session around these various issues and how, as a board, we should approach them. Who else should we bring to the table? How should we be able to work with the medical board? I think so that we're just not kind of flying by the seat of our pants with this kind of thing. I mean, this is a pretty important issue, and given that the most of us don't have that knowledge and expertise, that we should seek out the resources that can help us address it properly.
I think one avenue of resource is CPMA, and to consult with them, their executive officer, and to get their opinion. And I think we need to gather more evidence. I know that the major local hospital in my area, when I approach them, they have a different set of applications for physicians and surgeons, which DPMs are currently under, and another application for, quote, allied health, which we possibly would be sent to that application. That application process is completely different. That has been sent, and it was in the package. So I think this has the potential to affect every major hospital in our state that would have to change their bylaws and their application process. So that is something that we can do further research on at with CPMA's resources also.
Well, Dr. Cha, I
Yes.
don't think we want to be flat-footed on this and just wait and see what happens in March. We really need to start hitting the ground running. I think either our executive committee or our legislative committee starts formulating a strategy and contacts stakeholders and comes up with a plan. Either we produce legislation or hope that the association would produce legislation, or we may have to take two different avenues in regards to either scope issues and or BPM positioning within the statutes. They're two separate issues, and I think we need to really start working towards that and have something to propose by December.
I also suggest that we probably get an attorney, like a healthcare or an attorney that maybe specializes in, I don't know, practice, some sort of, to really take a look at this and see why this is, what's going on here. Because I just think it's not very transparent.
I mean, I think the thing to remember is there's always going to be someone who's for it, and there's going to be someone against it. I think what we need to do is formulate our position and then have the evidence and the information to back that up, whatever that is. I think without having a strategy, as Neil has pointed out, on those various issues, then we're kind of just all over the place. So I think the first step is to create a strategy and decide as a board, what are we going to do, and then bring all the stakeholders and have all that information available to make the case for our position. So we don't have that right now. So that's the directive that we need. We need to create the vehicle to have that happen. So is that going to be in the legislative committee? Is it going to be in the executive committee? Or will we do it as a board in a strategic planning session? So do we need a motion? What do we need to move forward?
What would we could accept a motion. What's the motion going to read? For the legislative committee to take this on, or?
Where he's suggesting the executive committee doesn't want to take the time, the alternative, and that's fine. If the legislative committee is willing to at least start investigating and start the process, the motion would be to have our legislative committee in conjunction with our interim executive officer meet with stakeholders or consult with stakeholders to start determining whether we need to pursue legislation for the board position in the future.
I'd like to amend that to make that the executive committee. That's okay.
I accept the amendment.
Okay. So do we have a second? Dr. Nancy seconded it. Any further discussions?
I mean, I just feel like it's almost something that's more appropriate for a strategic planning session amongst the whole board. I mean, I think it's a learning opportunity for the whole board to be involved in the strategy around how to address legislative issues or concerns. I mean, since it's such a unique opportunity, I just, I would be more inclined to have it as a strategic planning session. Now, if the initial directive is to have the executive committee, come up with a plan and how that moves forward, then I'm for that. But I think as a board, we should all have, some opportunity to engage in that discussion. So maybe I'm just not understanding what the executive committee do. Are they coming up with
Ideas.
the ideas around that? So then why can that be a larger board discussion?
We could do that. We could have at our next interview for the executive officer permanent search, we could have the strategic session then.
I mean, I also think that could be an opportunity for, SALA has a lot of resources, so I think if we approach them with, here's a matter that we're looking to delve deeper into, what resources would you suggest that we, bring to the table, then I think that makes a more fruitful discussion, and it allows the board to be a board.
Okay, that would be another option, is to convene as an entire board for strategic planning, perhaps in a few weeks.
Yeah, it remains to be seen whether we'll have second interviews. Hopefully we will.
Mm-hmm.
I think
If we don't, we still could meet and discuss this matter further. So it's not dependent on whether we have second interviews or not.
well, convening as a board, it's a public meeting, and the goal here is to be nimble and at least start communicating with the stakeholders to determine a course of action. I'm thinking initially just communicating with NBC and CPMA to figure out best options, and that should be brought before the board for additional discussion.
I agree, it gets the ball rolling. We could always meet as a board, but we need to get the ball rolling now. And then we could set another meeting after we gather more information and discuss with all the stakeholders involved.
This is Kathleen Cooper. I just want to talk about the logistics of this. I know how hard it is. We have to cancel some committee meetings, and this has happened in every part of the cycle. It's not just November. However, the committees will be meeting again on November 9th, which will be here very soon, and we still at that point won't really see what's in the Sunset Report until December 1st. So the preliminary steps that we take to brainstorm and have our meeting. I mean, it's possible that we do this in small increments with a smaller group on the phone and then meet whatever committee you decide to assign it to in November, or have I just want to draw the two things I'm hearing, or have a full board meeting prior to November 9th, prior to the next committee meetings, where we brainstorm on this. So I just want to know what you prefer.
I think Dr. Mansdorf's motion to have the executive committee meet and discuss with all the stakeholders is probably the best option at this point. We already know the last amendment that was drafted regarding SB 1039 and the role of podiatry in that. So I don't think that's going to change at all. So the arguments that we made still hold true, and the whole purpose of this is to discuss with further stakeholders and continue to prove that this is just a bad idea. And that's the whole purpose of Dr. Mansdorf's motion.
So is the motion to have the executive committee with the executive officer brainstorm ideas around how to approach this with whatever comes out of that brainstorming, then coming to the board for a larger strategic planning session around the plan of attack?
Correct. Is that correct, Doctor?
Okay,
Yes.
so then I can support that motion.
Okay.
Could you repeat that again, nice and loud?
So the motion would be, do I need to amend this motion? Or you need to amend it?
No, the intent of the motion was to have our executive committee, along with our executive officer, meet with stakeholders to propose a potential course of action that needs to be brought before the board for additional discussion.
And then I'm proposing that discussion happen in a strategic planning session.
Okay, we have, do you want to, let's discuss Dr. Mansdorf's motion. It was seconded. We're discussing his motion, and then certainly Ms. Dixon could provide her own motion. Is there any further discussion on Dr. Mansdorf's motion? Is there any public comments? Okay, let's vote on Dr. Mansdorf's motion.
Neil Mansdorf, aye.
Christina Dixon, aye.
John Shaw, aye.
Judy Manzi, aye.
Michael Zapp, aye.
Okay, that motion passes. Is there any other discussions or motions that would like to be made?
Yes, I would like to make a motion that the results of the brainstorming session of the executive committee and the executive officer then come back to the board and we set a strategic planning session to discuss the actions that the board will take to bring those ideas to fruition.
Do we have a second?
Excuse me, I need clarification. Would this be before the next group of committee meetings, or?
It could be at the board meeting,
Okay.
that it's a strategic planning session as an agenda item on the
December 3rd, okay.
or it could be with the committee. I mean, I don't know. We have to think about the best way to do that.
I have a question. With the sunset review, like, so they get there in March with their proposal, and then what's the time frame? What happens next?
Everything from that point on until the very end of August will be debatable. All of that is fluid until the end.
Mm-hmm.
So you have a few months there.
Okay.
Okay, so Christine, Ms. Dixon made a motion. Do we have a second?
I second it.
Okay, seconded by Dr. Manzi. Further discussion? So I just wanted to state that this doesn't have to be done here. It could be done, via teleconference. It could be done at a board meeting. So it gives us option. I think this subject matter is extremely important to all stakeholders and could have major ramifications. So if that's what's required, I think that's the right thing to do. And I think getting the entire board and all stakeholders involved is the goal. Because I still don't think there's going to be major unintended consequences. Any other discussion regarding Ms. Dixon's motion? Any public comments? Okay, let's vote.
Neil Mansdorf, aye.
Christina Dixon, aye.
John Shaw, aye.
Judy Manzi, aye.
Michael Zapp, aye.
Okay, that motion passes. Okay, is there any further discussion regarding SB 1039 or AB 2193 or this topic in general? If not, we will end the open session and we will be going into closed session at 1 o'clock.
If I may, I just
Sure.
want to add it. You can see from the notice of this board meeting, if the only issue pending after closed session is adjournment, then you will not see a webcast of that. So this will be the end webcast-wise, unless there's any business that's brought up after closed session for the public.
Okay. Yeah, we're not anticipating anything new. So that the telecast could end. And we're going to go into closed session.